The following news flash is brought to you by the Lone Star Lowdown, providing your daily bulletins for the commodities market. Today in history, news updates, and the inside scoop into the tides of the alternative. Markets for the 13th of January 2016 are currently trading with gold $1,094.74 an ounce, silver $14.14 an ounce, Texas crude $30.44 a barrel, and Bitcoin is currently at 429 U.S. currency. Today in history, Tuesday, January 13th, 1942, Henry Ford patents a method of constructing plastic bodies for automobiles. Although the formula used to create the plasticized panels has been lost, it is conjectured that the first iteration of the body was made partially of soybeans and hemp and other agricultural organic biodegradable materials. The car was designed to run on hemp oil as a conservation effort on steel and oil due to the rationing that resulted from the war effort of World War II. In recent news, Renee Wetzel, whose husband Michael was one of the 14 people killed in the Inland Regional Center terrorist attack in San Bernardino, California last year, is seeking damages totaling $58 million in claims that were filed late December. At least 4 claims within the county have been filed: $3 million for loss of wages, $25 million in general damages, and $10 million in general damages for each of her 3 minor children. The claim, which lists the county and 25 unidentified individuals as respondents, alleges that 37-year-old Wetzel's death was preventable and caused by negligent and careless actions of the respondents. Her husband, Michael, worked as a supervising environmental health specialist for the county. Scientists from the Los Angeles-based Cedars-Sinai Board of Governors Regenerative Medicine Institute conducted an experiment with gene editing technique CRISPR/Cas9, showing for the first time the possibility to treat retinitis pigmentosa, a type of inherited blindness, in laboratory test mice. Clustered, regularly interspaced short palindromic repeat/Cas9 or CRISPR/Cas9 is a gene editing technique that has the ability to alter genetic mutations that are known to be linked to illness. The case study involved test mice that were genetically engineered to mimic inherited retinitis pigmentosa. They were then injected with this CRISPR Cas system. A single shot enabled the mice to see better compared to the mice in the control group. The Lone Star Lowdown is currently looking for advertising. So if you have a product or a service you'd like to advertise with us, feel free to give us a call at 210-363-2257. This has been your Lowdown for January 13th, 2016.
My remedy today.
Okay, we are back. Graham Kelton, Real Raw Radio, and we're talking to Scott in Texas. So, based on this, Scott, I know Scott has some complaints he really wants to get filed, and he's kind of antsy, and I understand you want to clobber him good, but it's better we get it well structured first. If you will go to jurisimprudence.com, and up on the top, there's a link to Cherokee County. In that one, I have a very lengthy statement of facts. Wrote out the whole statement of facts, and then I wrote out the statement of factual accusation. And in this one, I combined them together. Now, when I do them now, I separate the two. I didn't at this time. But this is an example of how you do a complete statement of facts. And then within this, the statement of factual accusation, within there, you'll make the claim that he did this, this, and this. That amounts to a violation of this statute. And you write that accusation complete within your statement of factual accusation so that you can then take a criminal complaint, say, for tampering with a government document. You take that portion that makes the accusation of tampering, and you cut it out, you drop it in your complaint. In this one, I've got about 35 criminal complaints. I have the statement of factual accusation, and then when they read the criminal complaint, they read sections from the statute, from the factual accusation over and over. Like, I'll have them do one set of facts and make several claims against them. Tampering, obstruction, witness tampering, official oppression, all from the same statement of facts. And I'll put the statement of facts in based on the following. I have reason to believe, do believe that so-and-so violated this statute. And I just go in and change the statute numbers. So that, and always make every criminal accusation on a separate complaint. These guys are scoundrels. If you put more than one accusation on one complaint, they'll decide to dismiss one and throw the whole thing out and ignore the rest. So by putting each one on a separate complaint, they have to deal with each one individually. Does that make sense, Scott?
Yes, sir. Sure does. So
that's kind of the basics.
Okay.
And those basics will get you a lot farther than most lawyers ever get.
Well, I'll go and read Cherokee County over the weekend, and then I guess the next thing is get the factual. I got the statement of facts. I just need to get the factual, whatever the other one was.
Accusation. Or you can they'll call it points and authorities. What's the other? There's another term for it. But this is essentially a brief in support. That's what I was looking for.
Is that what the points of authority is? A factual allegation?
Yes.
Oh, I didn't know that. Okay.
Factual accusation, points and authorities, brief. It is essentially a brief.
Oh. Okay. Well, I didn't know you had to have a brief to support all this stuff too. So,
well, you have to. You give them the facts, and then you tell them the story. But we're not dealing in English here. We're dealing in legalese. So there's some rules to how you have to tell them the story. Primary rule is never make a proactive statement of law out of your own mouth. Never say that they can't do this, or they did this improperly. You got to say exactly how they did it improperly and what code, what statute, case law, whatever states that that's improper. Now, I quit using Lexis and Westlaw because I find the internet is much more valuable to me. I can find briefs. I can find primarily what I want to see is a court ruling, because the court rulings are very well written. And what I'll do is, if I can find a ruling on point, I cut the ruling out of the document and I drop it into my document, and then I change case and tense words to make it lead in and lead out of my document. When a judge reads that, the judge is going to know exactly what you did. He's going to know that you plagiarized that out of a court opinion, and that's exactly what he wants to see. That makes it authoritative. Now you're not making this statement out of your mouth, you're making it out of the mouth of the courts. If you will go on the internet and search your topic and look for legal briefs, do a search for traffic not in commerce brief, and then also points and authorities, Texas, and see what you get. We've got a lot of lawyers out there. We have too many lawyers. And lawyers can't, only in Texas is it against the law for a lawyer to directly solicit his business. It's a felony in Texas, barratry. So the lawyer gets out of law school, how the heck is he going to get any business? If a law firm doesn't pick him up, he's got a problem. He's got $100,000 to $180,000 student loan to pay off. He's got to make a lot of money here. Well, lawyers, since they can't solicit directly, they like to post stuff on the internet. Stuff about what they do specifically. If you got a guy that specializes in traffic, he's going to post a lot of his briefs and pleadings on the internet so other lawyers can find them. So if they need his expertise, they call him. Well, that's wonderful because we can find it. My legal research, I look up very little on my own. I go on the internet and find where somebody else has already briefed out the subject. I take their brief. You read some of my briefs. You thought it was pretty well written.
Yeah.
That's because I didn't write it. I just stitched it together. So,
well, I guess so. I mean, now we're getting into the actual topic I wanted to really talk about, which is actually writing of documents you can't, basically what you're saying is you have to open with a court statement saying, this is the reason I believe because of case law, and then you make a few statements of fact, and then it leads into another piece of case law to back it up, and then you go into more statements of fact, and then you use another piece of case law to back that up, and you just trickle right on down through this story because you actually put together a story, which is your timeline, and stitched it all together with case law to back up everything.
Yes, and it has to be a good story.
Exactly.
You're writing a novel here or a short story. You want to engage your reader.
That's going to be that's the hardest part, I would say, for a lot of people. I don't know, but for me, struggling out is writing the story and making it to where it's a 180-degree peripheral vision as you're going through the story to make it as descriptive as possible.
Here's how you do it. There's a magic way to do it. If you're married, take it to your wife and ask her to rip you to pieces. Don't hold anything back. Or take it to your mother. Take it to somebody who's has no compunction about just tearing you to pieces and have them rip it apart. It's difficult. It's annoying, but it is incredibly valuable. Most people who are not that comfortable with you are uncomfortable with tearing your work to pieces. If they can kind of figure something out, they'll gloss over it. Take it to somebody who won't cut you any slack. It's a struggle. It's difficult. But once you've been through that a time or two, you got it. You'll get it down to where you won't have any problems. The main thing is look at every sentence you write, every fact you state, and ask yourself, did I put everything in there to make sense? Am I going to create a question in the mind of my reader? Have I connected every single dot? It's harder to do than you think. And you'll never get them all. You'll have to get somebody else to do it. I send my documents to people all the time and ask them to just tear them to pieces.
Yeah, it's a whole lot harder than what you think. I know, because when I sit here and even the story that I know by heart, because I lived it, when you put it down on paper and then you try to really condense it to make the version starts changing. It's like, we're already on version 7, and I'm like, oh my gosh, it's amazing how once you start really trying to write it for the reader and not for you, it makes a big difference.
Absolutely. And we're only on 7. We should be at 22.
I actually cheated and didn't count about 4 or 5 changes along the way. So, yeah, it's probably around 12.
But it's okay. And when you're doing these, always save, when you make changes, save it in a new version. And don't throw out the prior version, because a lot of times you rewrite something, you make it worse. And as you continue, it becomes clear that this is not as good as something else I had. And then you go back and get it. If you have everything under a different version, you got it all. If what you're working on craps out and you lose it, you can back up a version. You don't lose so much. And once you have a final document, save it as a PDF, and then trash all but the last version. Keep a Word version and keep a PDF version. You keep a PDF version so you know exactly what you actually filed. You file the PDF version, because you won't be able to change that unless you go to a lot of trouble to change it. Word documents, we change those all the time with impunity. We wind up not knowing what we actually filed. So the last thing you do, if you have Microsoft Word and you don't have PDF converter, you can go online and download one for free so that it'll let you save it as a PDF, and then your documents will be safe. Okay, hang on. We do need to move along. Jimmy and Trude's been waiting quite a while, but we'll finish this up on the other side. Randy Kelton, Real Radio. Our call-in number, 512-646-1984. We'll be right back. Now.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Well, don't let nothing get to you. Only the Father can deliver you. So don't let bad mind people hurt you. Until Satan get behind you. Know what I mean? My friend. And all of your children. Come. Those things that hurt me free. Tell him your problem, babe. Call on his name once again. Miracle, you know he worth the aim. Those things that hurt me free.
Okay, we are back. Randy Kelton, Real Radio, and we're talking to Scott in Texas. Okay, Scott, are you going to have a version ready for me tomorrow.
Yes, sir. I'll get to work on that, and I'll have it over to you tomorrow, and I will be in touch with you.
Just as a matter of practice, when you start the argument in support, don't worry about getting all that right. Just go through it and add everything you can think of. And don't worry about looking up all the law. You want to get everything in there first. Because once you got everything in, then you go in and you start stitching it together. If you try to get it all right at once, it always turns into a mess. So just go down and you find this cool case law and you say this goes here and you stick it in there, reference to it in place, and you just keep going. If you get stuck on a place, just jump over it and keep going, because as you begin to put these pieces together, it's like a puzzle. One piece down at the bottom will free up something at the top where you got stuck, and it will kind of develop itself. So just put everything in there, and then we can go back and look at it and shuffle it around. It'll go a lot quicker than don't spend too much time trying to get it perfect the first time or two around.
Well, on these criminal complaints, though, I mean, wouldn't it be just pretty much like a simple would it be an opening statement of law to the actual whatever one or two line sentences that the criminal complaint is, and then any supporting law that would have to back it up? Is that how would we go on a criminal complaint? You
could write a criminal complaint to look like an information. An information. If a prosecuting attorney receives a criminal complaint, that criminal complaint is intended to be written by a citizen. If a policeman gives a prosecutor a criminal complaint, he does not do so in his capacity as a policeman. He does so in his capacity as a citizen. So it's intended that citizens write criminal complaints. And because of that, they're not expected to be perfect. So when the prosecutor gets a criminal complaint, he is to reduce the complaint to an information. An information is exactly what the complaint should look like when you give it to the grand jury. Except prosecutors are not very artful. They'll just put in an extremely brief statement, and then they want to go in and testify before the grand jury or bring witnesses. You're filing complaints, you can't do that. So you want to testify in the complaint itself. When the prosecutor, if the prosecutor gets it and turns it into an information, then he'll take out all of your argument. But the grand jury gets the complaint along with the information. And that's so that the grand jury can look at it, or a judge can look at it and make sure that the information accurately reflects the complaint. You want your argument in front of the grand jury. And you always write for the grand jury. If you're making accusations against public officials, they are required to go to the grand jury. So you want that argument, you want that complaint to be complete in itself, so that the reader doesn't have to go somewhere else to check for information. Everything they need to know to make a determination is right there in front of them. So I write my statement of facts in a way that every complaint that's in there, the section where I talk about this complaint, I have all the facts I need to support the complaint. And then I could just go grab it and drop it in. So they will get the complete statement of facts, and then they'll get the complaint that's extracted from the statement of facts. So when they read the complaint, they read it in the context of the overall situation. So they have referential index. They've probably read the accusation, the statement of factual accusation already anyway, to find out what's going on. And now when they read the complaint, they say, oh yeah, that was right here. They have a reference to how this fits into the overall scheme of things. Makes it make more sense to them. Did that make sense to you?
Yeah, okay. So now and I'll let you go because I know you want to get to everybody else. But a statement of facts is basically for our records, and a statement of factual allegations is basically a summary, a brief or whatever, that you can turn into the court, and then you can extract pieces out of that to make criminal allegations.
Yes, but you want a complete statement of facts as a verified affidavit. So that puts the facts before the court.
Got it. That's the story. Got it.
Yeah, the facts are just the facts. And
Right.
The court, this becomes facts before the court that the court has to consider. When you've filed that affidavit as a statement of facts, the court must accept your statements as true unless they're challenged by an opposing party. So the court has to accept all of these as true. If you have them as a verified statement of facts, there can't be any argument, any opinion in there. The court cannot take notice of an opinion, only a fact. That's why you're real careful about that statement of facts. You want to put that in an affidavit, get that before the court. So the court must determine the facts in accordance with the rules of evidence. This gets the facts in front of the court in accordance with the rules of evidence. Now he has a duty to apply the law to those facts. He can't ignore any of them. We get this all the time where the courts don't pay attention to what people put before the court. And most of the time it's because they didn't get the facts in the record.
Yeah, we get back to that.
By verified affidavit, you got it in the record.
Okay. Oh, man, well, this was good stuff. Hey, everybody out there listening, man, y'all tell everybody to tune in to Randy. He has got it going on, and he is killing it here in Texas. I'm going to let you go. I'll talk to you tomorrow. Thank you for everything.
Okay, yeah, and I'll have the check in the mail for that promo there.
Oh, don't worry. I was expecting $1 million, so I'll be beating on your door. Don't worry. Anyway,
okay.
Have a good evening. Y'all take care now.
Okay, thank you, Scott. Now we're going to go to Jimmy in Maryland. Hello, Jimmy. What do you have for us today?
Okay, Randy. How you been?
Been good.
Good. Yeah, I just wanted to update you on some things that's been going on. I know it's been a while since we talked. I'm the guy that opted out of the corporate scheme, turned my license in and everything, and I have some traffic issues up here in Maryland.
Okay, how did that come out? This was your second driving driving on suspended, or was it driving without? What did they charge you with?
It was three. Right, three times I've been cited for driving without a license and driving on a suspended license and convicted. Okay.
How did it go this last time?
Okay, last time I had a violation of probation hearing, and they got me public defender. And she was saying, because I filed a writ of habeas corpus in the federal court, she was basically saying, telling me that if I prevail with the writ of habeas corpus, it would do a stay of everything that the circuit court is trying to do. So she was worried about my liberty and freedom. She's worried I get locked up today. So go ahead and just agree to it. And if you prevail with the habeas corpus, I'll put a stay on what the court does anyway. And so I followed her lead, and so I went ahead and, agreed to it. And I
agreed to it. What was it?
The terms is.
Okay, hold on. We're having trouble. You're kind of breaking up on me. We're about to go to break, so we'll see if we can get this fixed over break. Are you on a hands-free or a Bluetooth?
I'm on my phone, my cell phone.
Okay. See if you can, is there a place where you might get a better signal? Okay. Hang on. We're about to go to break. Randy Kelton, Louisville Radio. We'll be right back.
Is it possible for radio waves to make you sick? Many people think so, and some are taking refuge in the remote mountains of West Virginia. I'm Dr. Catherine Albrecht, and I'll tell you about something called the Radio Quiet Zone next.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Wi-Fi, power lines, and cell towers bombard us with radio waves. But for some people, even low levels of this radiation can be debilitating. The condition called electromagnetic hypersensitivity causes acute headaches, burning skin, and chronic pain. The effects are so bad that a colony of Wi-Fi refugees has taken root in the U.S. Radio Quiet Zone in West Virginia. That's an area where all radio transmissions are banned because of the sensitive radio telescopes located there. Gas refrigerators, wood stoves, kerosene lamps. These folks are all too happy to live free from electricity and the radio pollution they say goes with it. I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
Live Free Speech Radio, LogosRadioNetwork.com.
Okay, we are back. Randy Kelton, Rule Law Radio, and we're talking to Jimmy in Maryland. Hello, Jimmy.
Hello, Randy. How am I sounding now?
Much better.
Okay, good. Yeah, I'm outside now.
Oh, good. It sounded like your mic was booming and you were clipping off at the top, and I was losing part of it. So you sound a lot better now.
Oh, okay, good. Okay, when I was trying to explain to you, I had a violation of probation hearing for the 2 previous charges. And the public defendant that represented me, she convinced me to go and plead guilty to the violation of probation period because I had a writ of habeas corpus that was filed. And she said if I prevailed in that, then it would set aside what the circuit court was doing. If I went to guilty, that writ would set aside whatever they did. That's what she explained to me.
Yeah, that's true. But the likelihood of any court in Maryland overturning their traffic code is somewhere between little and none, because they'd lose all that revenue.
Well, I'm going to go to the federal court with it. I mean, you got to exhaust your state remedies. Like I had to file it in the state court first, and then over to the federal court.
Oh, then that's a maybe. Still, the federal courts, they're not that great, but they don't have the investment that the state court does. So
exactly. But see, we got like what Eddie said. This is a legal impossibility. If I don't possess a license, how can I be convicted of driving on a suspended license?
Exactly. So that may, if you're not you're not trying to get the law. You're not trying to get them to say that they can't ticket you because you're not in commerce. You're more specific in that you're arguing the issue that you can't be charged with not having a license or having a suspended license when you never had one in the first place.
Right. How can you can't suspend something that does not exist?
Yes, the legal. That's a good point where they can rule in your favor and not overturn existing law. And all they would have to do at the enforcement level is give you a different ticket. Wait a minute, no, they can't give you a different ticket.
No.
Ooh, you may be back in that conundrum.
Yeah, these cases are back from like 2013. They can't just give me something new.
Yeah, what is going to happen if the court rules in your favor? How is that going to affect enforcement of the requirement they perceive for people to have a driver's license?
Yeah, they're trying to make me get one. They're telling me, to go get a license, and you'll come back to court and pay the fees and come back to court and show I have a license. Then of course I'm going to do that.
That sounds like they're forcing you to contract with them.
Exactly. That's what they're doing.
And they're not allowed to do that because the driver's license is a contract.
Right. That's the whole understanding from me pleading guilty. They'll get a license, and that will solve this issue. So that's where we are now, where I'm doing my writ, trying to go through the state level to the federal level. And my argument I was trying to invoke is I have not exhausted all my state remedies. So the case is still pending. I'm trying to get through federal court. So I'm feeling that the circuit court should not enforce that when I'm still appealing the matter due to writ of habeas corpus.
I'm wondering what the likelihood of a positive outcome on the habeas, and I'm doing this from the perspective not of rule of law, but from the understanding that everything is political.
That the court made error by finding me guilty on driving on a suspended license when I don't.
Wait a minute. There's another consideration we need to take. You're doing a consideration based on law. Good luck with that. We need to do a consideration based on politics. What happens if the court rules in your favor? What happens to the state of Maryland in the long run?
Well, I'm not really anticipating that the state court is going to rule in my favor. I believe when I take this to the federal level, that's when everything's going to change.
Okay. So you're planning to go to. So you're not in the Fed yet, but you're planning to go there.
No. I made a mistake on the last policy. I filed in the Fed, and the judge ruled that I got to exhaust my state remedy, so I had to file in the state court. So that's why I'm at now.
Okay. What claim did you make in the state court? Okay, The reason I'm asking that question is I'm looking for a separate federal claim that you could ultimately make in the federal court.
Denial of due process.
Okay. Wait. Is that the state court claim?
Well, in federal court, I did both in the state and federal court. That was one of the claims, denial of due process.
Well, how is due process, how would it be different when you filed in the Fed? Because if you get a due process adjudication in the state, then the court's like, if you're filing in the Fed for the same issue, what would be the federal due process violation that would separate it from that a state couldn't hear?
Well, I'm thinking, it'd be somewhat a down due process in the state and versus denial of process, a due process in the federal.
Okay, here's the problem. If you file a due process in the state, then you're likely to be subject to res judicata as concerns filing in the Fed.
Mm-hmm.
If the state has adjudicated the same issue on the same set of facts, you may be subject to statutory to estoppel.
Yeah. Also, I didn't mention back in 1999, a judge dismissed or found me not guilty on driving no suspended license. So that was in another county, the same state, a different county. And I tried to use that argument about res judicata. This is already adjudicated. That I was found out guilty, and I'm riding in good faith that I do not have a suspended license because the judge ruled not guilty on that, but they didn't want to take that because it's a different county.
Did the judge in the other county rule on the same set of facts?
Yeah, with the same evidence as far as the license was fully suspended back in 95 and all this time.
Yeah. So he ruled on the same issue, same facts, and found in your favor. Now you come to another court, and they find against you.
Right.
Have you claimed good faith reliance on competent authority?
Say it again.
Have you claimed good faith reliance on competent authority?
I didn't say competent authority. I just said that I did this in good faith according to what the ruling was from the.
Okay. You made the claim then. You took these actions based on what a court had already said.
Mm-hmm.
So that's a good claim, and that would be an easy claim for the appeals court to give you remedy with that wouldn't change the law as they know it, because they could say, okay, this judge over here rendered a ruling that we don't agree with. However, this person who got that ruling had a right to consider that ruling as accurate, and therefore he's acting in good faith reliance on this judge's competent authority. You get a good shot at that one because it's politically easy. It doesn't make it so that Maryland can no longer enforce the requirement to have a driver's license. That would be hard to get, but to get to say a judge made a mistake and you relied on the judge's mistake in good faith, that should be enough to get it tossed. Hang on, Randy Kelton, Wheel of Law Radio. Our call-in number, 512-646-1984. We'll be right back.
Easy.
Okay, we are back. Randy Kelton, Wheel of Law Radio, and we're talking to Jimmy in Maryland. Okay, Jimmy. So now you're waiting for the state supreme to rule on your habeas.
Yeah, well, that's nothing I have to ask you about. I had to file two separate writs of habeas corpus, and with my indigency status, I filed a waiver. The judge just denied my waiver of both, so I was trying to figure out what do you do when you file for a waiver of court costs and the judge denies it, and you have indigency. I'm not sure if I have to get somebody to pay on my behalf and file affidavit because I could not pay and they paid on my behalf.
Have you filed inability to pay?
Yes, it was denied.
Ooh.
It was just recently denied, both of them, same day.
Have you appealed the denial?
No, I have not. You got like 10 days. The notice says you got 10 days to either pay it or the case. Nothing will happen to the case. It just won't do anything.
Okay, so you did. Okay, when was the ruling made? Are you within the 10-day time period?
Yes, I'm going to say. Yeah, it was denied on Monday.
Okay, then you most likely don't have to have the appeal in. Just have the notice of appeal in. Check that.
Sure.
Because generally you get 30 to 60 days to do an appeal because you have to write an appellate brief. You have 10 days as a rule, and like here in Texas, to give notice of your intent to appeal. And that's just a motion that says, here, I give the court notice of my intention to appeal. Now they've got notice. Now they get all the paperwork in Court of Appeals. And then you generally get 30, 60, 90 days, depending on the state, to write your appellate brief.
And it just feel like that I was denied the waiver of court costs to process the
that's essentially something that would be subject to interlocutory appeal.
Mm-hmm.
Because it essentially disposes of that issue. You need to be able to address this in order to continue with the case. So give them notice of appeal.
Mm-hmm. Sure. You mean if I was addressing it by providing pay stubs, things like that?
Wait, didn't understand that.
I said when you say addressed it, you mean as far as showing my pay stubs and showing my indemnity status?
Yes. Without that, that's essentially a dispositive motion as to that issue. This issue is not connected to the rest of the case, so this should be something you can appeal directly. And you don't have to wait till there's a final adjudication. Essentially, you have a right to an interlocutory. You should have a right to an interlocutory appeal here.
Okay.
At least give them notice. If there's something that would keep you from it, they'll let you know.
Okay, so they say the notice of appeal, and I'm going to appeal the decision of the judge by denying the two waivers of court costs.
Yeah.
Okay, I'll look into that.
Yeah.
Okay. Let's look into that.
Okay.
Now,
Is that it?
Mm-hmm. No. You saying at the break that you should have a good, strong issue as far as with the previous judge ruled about I was not guilty of driving on suspended license.
Yeah, that you were acting in good faith reliance on competent authority.
Right. Yeah, but the judge came and said it was turned in, and the prosecutor, it was turned in and destroyed. And
wait a minute, that didn't make sense. It was turned in and destroyed?
The record that they provided in the case, it's there right there, the driving record they provided, it was written right and it's turned in and destroyed.
Okay, you're using pronouns. And I don't know what the pronouns go to. Use the term the records. Are you talking about the records of the case where the judge ruled in your favor?
Yes, I'm talking about the record of the case where the judge in my favor. The prosecution provided a so-called driving record. He read it straight from the evidence. It said, prosecutor says right here it was turned in and destroyed, referring to the driver's license was turned in and destroyed, so it does not exist.
Okay, the driver's license was turned in and destroyed.
Right.
Okay, not the records in the case.
No, the driver's license.
Okay. So that's essentially irrelevant to this issue. You were accused of driving without a driver's license or on a
suspended license.
It's a suspended license when your license is never suspended.
Well, didn't exist.
You didn't have one to suspend. So in this prior case, it was ruled in your favor that you weren't driving on a suspended license. Is that correct?
Right. That's correct.
So you relied on that case. That should, if the state of Maryland rules that you can't rely on a court decision, then that gives them bigger problems.
Okay. That's what I'm going to go with that. And that's what I'm going to go with that.
Okay, so
I have enough. Mm-hmm.
Get your notice of appeal in, keep your case alive. Do you have anything else?
Yeah, another thing. When I was cited, they cited me with a fictitious license. Because they couldn't find me in the system, they created a license to cite me with that was supposed to be suspended, but that doesn't exist either.
Do you have a copy of the license they created?
Yes, I have the number, yes.
Do you have a copy of the license they created?
No, I don't have it. It doesn't exist. There's no license.
Well, did you request it under discovery?
No, I didn't request it under discovery.
How do you know it doesn't exist?
Because during the trial, the prosecutor came out and said the driver he produced, he basically made notation of none. It said none of that, none.
Okay, no. You're going to an argument.
Mm-hmm.
How do you know the driver's license does not exist?
How do I know it's
I understand that you can infer that it doesn't. That's not good enough.
Mm-hmm.
Did the prosecutor say that there was no actual license?
He did.
Okay,
he did.
that's
when he was talking. Yeah, he did.
Is it in a transcript?
Yes.
Okay, then you got
In
it.
the trial.
So you should have a good shot.
Yes, but the problem also, Randy, is this: I'm supposed to go pay 20-year-old fines to get a license to bring them back in April. I have to be back on April 7th. So I have to go do that. But we got some issues here because me being cited on a fictitious license, that's the license that they found me guilty on was a fictitious license. That's the license that I turned in back in '98. So
Okay,
I don't know what.
I'm not understanding why that matters.
Well, it matters because they're expecting me to pay these fines and these fees in their court and get a license, but it's two different counties. Same state, but two different counties. So when I give them information about my name, my date of birth, I'm going to take driving classes and also get the license that I had before, but they're looking for me to pay something that they messed up. You know what I'm saying? So I can't pay for something that they didn't do right.
Okay, somehow I'm missing something that's not making sense. Are they saying you have to get a license? This is a state license, so you're not having to get a license in two counties. What are you having to pay in two counties?
No. The problem is the convictions were on the fictitious license. That's the problem. They had no record of the license I turned in. They had no record of that when I went and checked with the clerk in the court. They had no record of my truthful information. The record only exists with stuff that's not truthful.
Wait a minute. Miss that last part. You're breaking up again. Can you move the mic a little further away from your face?
Let's see. Okay, is that better?
That's better.
Okay. No. What I'm trying to explain to you is I was cited on a fictitious license. That's the license that I was convicted with. That's the license that I actually had in the past.
Okay. You were convicted on that license. Okay. What about it?
They expect me to go and pay these fines and these penalties in their court, but I'm unable to do that because it's not my driver's license.
Okay, you're not making sense. You said you had a driver's license. They ticketed you on that driver's license, and now you're saying it's not your driver's license. So which one is the license they fictitiously created? I'm mixing these up.
I was cited on a fictitious license. When I was cited here in Charles County, it was a fictitious license.
Did you have two licenses?
No, I don't have two licenses. I never had two licenses.
Where's the second license? You're not making sense here. You're just saying you were citing on a different license. What is the different license?
The records are different.
Oh, I'm getting confused here. The pieces aren't fitting together. So it's not the fictitious license. So this means there's a third license involved here.
No, it's only two.
There's only two. The two are yours. Then there's a fictitious. These are mixed together. You're using pronouns, and you're not being specific on which license you're talking about. And I'm not able to put these pieces together. I'm still having a little trouble understanding you. Hang on. Randy Kelton, Real Raw Radio. Our call-in number, 512-646-1984. Give us a call. We'll be right back.
Story for everyone to hear about how we're not gonna give in to the fear. Yeah, it's a story. I will occupy my father's house till he returns. I will occupy my father's house. He has left me with the strength and wisdom. I will aid my concern. My father's house. Yeah, I will occupy my father's house. says, here comes Peyton's place. I feel like my
Like a thief in the night, I saw the father enter. She saw the parasite from around her. The defibrillator and heal the murderer. Chase them out the house because them cannot enter. Pure in heart and clean hands only. Only them could enter in God's house, you see. Save your soul, surrender quick.
Okay, we are back. Randy Felton, Rural Radio, and we're talking to Jimmy and Marilyn. Okay, I was getting confused there at the end. It sounds like there's three licenses, but there's only 2 licenses. I'm not sure how all 3 of these tickets are working together.
Okay, now this county here in Charles County, when I was convicted, they submitted 2 driving records. One was a fictitious license that has a different date of birth. It has a middle name. I don't have a middle name. It has a middle name and a different date of birth. That's what I was cited with. They submitted that, and they also submitted in the license that I turned in. So they used both of them to convict me with, but they processed the fictitious license.
Wait a minute. You know all these details, and you're using pronouns that refer to some individuals, but I'm not sure exactly which ones they are. So you had a license you turned in, and they had records of another license. Okay, when did this occur? Was this the one that was dismissed, or was this after the first ticket was dismissed? That was on your actual license that you turned in.
Yes, back in the 1990s, yes.
Okay, then you had a second citation, and is this when they came up with 2 separate licenses?
At the trial, they submitted 2 driving records. I was cited with one license, which was fictitious, or is fictitious.
Okay, were you cited on the license that you turned in, or were you cited on the second set of driving records?
I was cited on the second one, the fictitious one, and that's not mine is fictitious.
Wait a minute, I didn't understand that. Were you cited on the license you turned in?
No.
Okay, so you were cited on another license on this fictitious driving record. Did you?
Yeah.
Do you have that driver's license number?
Yes, I do.
Did you request the application for the driver's license?
No.
Why not? That would have seemed to be the first thing I would have done.
There isn't any.
How do you know?
Because when I find out what they do is when they cannot find you in the system, they'll create a number.
No. Well, hold on. This is not how we can do things.
The police, when they cite you,
you can't go to court and make an argument about how they do things. You need to be able to go to the court and say,
something to you.
Listen, you can't go to court and make this argument. You got to get your facts. You got to be able to go to the court and say, I went to the state and demanded these records. The state was unable to produce these records. Therefore, these records don't exist. If you go to the court and say, well, they do these strange things over here, and that's why it doesn't exist, that's conjecture on your part.
No, I'm sorry.
You may be right, but as far as the court's concerned, you're not giving them any facts, so they can't rule on it.
I did go to NVA to request, like I said, to request for this. They have no record of it.
Do you have that in writing?
No, I don't have it in writing.
Then you don't have it. You got to get it in writing. Give them a written request.
Okay.
The court can't pay any attention to he said, she said, because that becomes hearsay.
Okay. But also the code says that they do not give out more than one license. They only give out one license per person in the code. So that's probably their own policy that did that.
Okay. That's a good argument, but there are facts you have to have in place.
Mm-hmm.
And a written request to the state with a written response from the state saying they have no records responsive to your request, now you have conclusive proof that it doesn't exist.
Okay, I see what you're saying.
Or if they do find it and they send you the records, you're going to have proof that this is somebody else, not me.
Mm-hmm.
But right now, get in your motion to appeal and then get written requests for. What about this fictitious license? Have you put in a written request for the application for it?
Okay.
Put in a request for that one. If they created a fictitious license, that's criminal.
Well, I know it is.
And you turn it back on them, and if you can show that they committed crimes in the process of the prosecution, then you go for the unclean hands doctrine.
Well, I got that too. Like Eddie explained to me, when they retroactivate a license that that they retroactivate the license that caused injury, that's a crime.
Have you filed criminal charges against the prosecutor?
Not yet. I've only done bar grievance so far. I haven't done that yet.
Have you filed a bar grievance against the prosecutor?
Yes, sir.
Ah, good. Okay, well that part's good. Okay, so are these issues in your habeas?
No, but I can amend it. Since the situation going on that they haven't processed, I can always amend it.
Wait a minute. Why is it taking these guys a long time to hear your habeas? Habeas is the great writ. Everything stands down before habeas.
Mm-hmm.
They're supposed to drop everything they're doing. I was in Montgomery County, Texas, Corsicana, north of Houston, and they stopped a murder trial to hear my habeas.
No, it took her like 3 weeks before she finally ruled on my. I filed it back in the middle of December, and like I said, she just ruled on the waiver Monday.
You should look at the Maryland state law on habeas, because normally habeas is the great writ, and everything should stand down before the habeas.
Mm-hmm.
But if it's a habeas that doesn't include incarceration, then there may be different rules for it.
Okay.
But anyway, I guess your main thing you need to do right now is get your notice of appeal in, and then get written requests for everything that you need to show. Even if it's something you know they can't produce, ask for it. Force them to send you something that says they don't have it. Then it's not hearsay. It's not he said, she said.
Okay. But as far as me trying to meet this thing in April, so I can't present an argument that.
Wait a minute. You can't do that to me. You can't use those pronouns. This thing in April. What are you talking about?
I have a sentencing hearing in April for pleading guilty to the violation of probation, which means I'm supposed to get a driver's license with ADCs. I'm still appealing the issue. I can't plead that. I cannot plead to the court that I have not exhausted my remedy.
Oh, you might. Okay, this is the one where okay. If you get a positive reading on your habeas, will that eliminate this issue?
That's what the public defender said. It would set aside.
Okay, file a petition file a plea in abatement.
Mm-hmm.
You ask the court to abate all proceedings until the habeas is heard.
Okay, that's what I need to hear.
Because it's unreasonable for them to hold this hearing if the habeas would render this whole issue moot. It's an improper use of the court. So look up plea in abatement in Maryland. It may have a different name in Maryland.
Okay.
Might be motion for stay, a restraining order. You might even petition the court that has the habeas for a restraining order to restrain this court from moving ahead.
Okay. Yeah, I'll get on that. That's basically what I'm trying to say. Because as you see, a lot of confusion, a lot of mess to clean up, and I apologize for my lack of clarity.
And part of it is I'm having trouble understanding you.
Well, that's some of that is on me. My lack of I'm a stickler for clarity, and I got
no. I'm saying the phone itself, the fidelity. I'm having a little trouble with it.
Okay. So those issues I'm having where they have no. When I went to the clerk of the court to get a record and see what exactly I have to pay and everything, she looked me up, could not find nothing.
Okay, anytime I go to the clerk and ask for a record that I need and they don't have it, I immediately write out a written request and give it to them. And they tend to get excited until I explain to them. They say, we just told you we don't have it. See, I know that. So I need you to respond to this with a letter saying we have no records responsive to your request.
Thank you.
That then they know what you're doing, and if they're pulling some shenanigans, they're going to get real excited.
Okay, so I can do that check and go there and give them some documentation requesting for what I verbally requested for, and
Exactly. Yeah, never do anything verbal anyway. If it's something that you need, always ask for it in writing.
Okay. And see, this is what the defendant told me. Is that I'm worried about you going to, she's able to get continued till April, because I suppose to have it. It was on the 5th, and the sentencing got postponed. And she's telling me, go down to the clerk and get this information, verbally.
Okay, wait a minute. I'm having a horrible time understanding you. I'm only getting half your words. Okay. I think I've lost you all together. Okay, we're about to go to break. Randy Kelton, Rule of Law Radio. Our call-in number, 512-646-1984. We'll be right back.
This is the Logos Radio Network.
Oh, come on.
Okay, we're back. Randy Kelton, Rule of Law Radio. And Jimmy, we really need to move on. I've had Truth here waiting for almost the whole show. Hello, Truth. What do you have for us today?
Hey, Randy. Hey, it's Harold the Truth Reader from Northwest Truth in Oregon. Here, you saved the best for last. Well, that was quite interesting. Their debate of confusion and facts and figures and things. I don't know. Anyway, that was fun. Anyway, all good. I got 4 questions for you, and then I have the story to tell you about me calling the watch commander of this officer who accosted me on October 31st for the impounding of my truck, the arrest, and I guess, the false imprisonment, I guess you could call it. Cuffed me and stuffed me back in the unit there, and then, he claimed that he was arresting me for not presenting an ID. Failure to present is the charge in Oregon. That's what they call it. It's supposed to be a violation or something like that. Anyway, I got 4 questions for you. What do you think of this?
Okay, hold on. Before they...
Okay.
Failure to present an ID. Have you read the statute?
I'm going to look that up. That's in the story that I asked the watch commander when I called him. I better call first before I go down there, because they tend to have a reputation of maybe giving you a hard time or perhaps arresting you if you try to file a complaint against an officer at the station. I've seen those videos, and I better call first, and then I'll see what I can do afterwards. But anyway, concerning that story, the officer says I have no valid complaint. He did everything according to procedure, and it was perfectly lawful, and I have no complaint.
Okay. You didn't answer my question.
Yeah.
What does the statute say? The reason I'm asking the question. You're in Texas.
Yeah.
Failure to ID is a crime. However, you can only be charged with that crime once you have been arrested. If you haven't been arrested, you cannot be required to ID.
Okay.
Check Oregon.
Now, in Oregon, they do. They're consistently the same as in other republics. That when the officer turns on the lights and pulls you over and makes contact with you, you're already in a custodial arrest.
No. The courts have. We're in a custodial arrest in Texas, but they call it a custodial arrest. They use the word arrest, but it really doesn't mean that. You're not considered. You're not considered to be actually in custody. It's a play on words. It's a Terry stop.
Okay.
So you're not actually under arrest yet. Check your statute. See if it requires you to be under arrest. In order for him to do that, he has to have reasonable probable cause that you've committed another crime other than to do with ID and has taken you into custody for the commission of that other crime.
Okay.
You can't just stop somebody and demand ID. It's been fought all over the country, and it's been beat all over the country.
Okay. Even in a traffic stop, I can't demand you to present an ID.
Nope.
A photo ID. Okay. Well, he demanded that at the scene there. That was the whole...
Oh, hold on. Let me back up.
Okay.
Okay, this gets into transportation. That's questionable. He can require a driver's license. And what does the code say in Oregon about a driver's license? In Texas, when you apply for a driver's license, you're applying for a commercial license. And part of the agreement is that you agree to present the license to a police officer when requested. And here's where our little sticky issue comes in. You can't require a private citizen to ID. If you force a private citizen to enter into a commercial contract, then the citizen can be forced to produce the commercial license. That'll put you in a conundrum because they're enforcing the traffic code against people who should not be under the traffic code, who are not in commerce. Now they can take away another right, and the right to be free from unreasonable search and seizure. And that's what that statute goes to.
Right.
Something I'd have to research, and something you might want to research.
Yes.
If this is about a traffic ticket, understand it's not about the law. It's all about money.
Right.
They want to make money from you. My last speeding ticket, we get to court, and the judge said, "Is the prosecution ready?" And the prosecution said, "No, Your Honor, we're not ready." Judge said, "This case is dismissed." I object. They didn't want to go to court with me because they knew that if they held a hearing, no matter what they did, I was going to start giving them all kinds of grief. So they just wanted me out of that building. Now, that doesn't have anything to do with the law. It has to do with money.
Yeah.
So,
Bet.
do this research. This might be a good claim to make, if you have a good claim here, that because they force you to they force you into a private contract. Forcing you into the private contract causes you to give up your right to be free from unlawful search and seizure. What they are not going to want to happen is to get a ruling against them. And if you can bring them a issue that they haven't heard before, lawyers really suck at doing research. They hate it. They hate especially to research issues they've never addressed before. Because lawyers are afraid of making a mistake. If you make a mistake, the judge is going to rule against you. If they make a mistake, the judge can sanction them. So they hate it. They're going to want to avoid it. It's going to cost them a lot of money. And if they think you're going to stay right after them, or you have an issue from which you may actually get a positive decision, they are not going to want that to get in the courts. In the foreclosure issue, we have the Jazanowski case. I cannot believe the moron banks let this get to the United States Supreme without dealing out with these guys. These two people, on the last possible day, you got 3 years to file a rescission. On the very last day, they filed a notice of rescission claiming that when they went to closing, there were two of them, but the lender only gave them one notice of the right to rescind, not two. That was their grounds for rescission. And these morons let this get to the Supreme. And the Supreme hammered the lender big time. And I'm looking at this and thinking, who is the moron who did that? So here, if you get a good legal question they're not going to want to answer, good chance they'll toss this thing because they do not want to risk getting into court and getting a ruling against them. It's going to cost them a lot of other cases. Am I making sense?
Mm-hmm. Yeah.
So let's look how we can sting them. And Eddie's good for this. He comes up with more first blush issues than anybody ever saw. Do you listen to Eddie on the Monday Night Show?
Oh, yeah. I frustrated him quite a few times.
Good. He needs it. He deserves it. But if you can find some, this is not about law. It's about the politics of the situation. If you can get the politics on your side, you got a good shot. So what really cool, obscure legal issues can you bring up that's going to make them look like they're going to be fighting you in court till you both get old?
Yeah.
First thing is read that statute, and then get case law on how the statute's been interpreted. You may find an open door in there.
All right.
Hang on, Randy Kelton, Real Law Radio. Our call-in number 512-646-1984. We got one more segment, and no more callers. So if you have a question or comment, give us a call. We'll be right back.
The Indian government may be wiping the smile off of Colgate's face. Activists claim the toothpaste giant patented an ancient Indian recipe they've been using for thousands of years. I'm Dr. Catherine Albrecht. I'll be back in a moment to tell you more.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Is Colgate a copycat? Indian activists say the company's newly minted patent for tooth powder is an ancient recipe, and they plan to fight it. Colgate is brushing this off. It claims a new twist on the traditional formula. The patent calls for red iron oxide instead of red ochre, but red ochre contains iron oxide. The threatened patent challenge could have teeth. In 1995, India fought U.S. efforts to patent turmeric. India won. In the meantime, India is documenting 30 million web pages worth of its ancient herbal formulas. Officials hope this step will prevent companies like Colgate from patenting India's age-old recipes. I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
We'll be kidding about chemtrails.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
I see two. Yeah, but I see twos of ingenuity.
Okay, we are back. Randy Kelton, Rule of Law Radio, and we're talking to Truth Raider in Oregon. And I kind of bushwhacked you. You had 4 questions.
Yeah, I did, Randy. Yeah, thank you very much again. I appreciate and I really enjoy your philosophies on things and how the way you handle it very smoothly. That's very comforting and inspiring to, just take it easy and just try to have fun with this. It's only fun, though, if you win. If you know what's going on.
Yours is traffic, so it's not like they're going to hang you up by your toenails.
No, but the problem is this is going to be perpetual. If I continue to try to do this, Matt, I don't know what I'm doing, then I'm going to have to be perpetually in court all the time fighting this and getting the collection notices in the mail. So, that's an interesting thing too. Here, this is a red herring about this. It definitely is civil because as I told you last week, I got a bill for both of the tickets that I had. The very first ticket out of the 3 tickets that I have a $4,000 lawsuit that they're trying to collect against me with a collection agency.
Did you bar grieve them?
No, not yet. I have maybe 22, 23 days yet. It was on the 7th when my court date was, and I have 30 days in which to do something. So there's some things I want to do there. I'm trying to put together a strategy of things that I'm going to do to file for that court. Anyway, let me get on to the questions here, and then we'll talk about that. The first question is, what do you think about the UCC 1308 filing? Is that legitimate? Is that something that you can do?
UCC 308 filings?
Yes, it says UCC 1, and then it says 308 filing.
I am not familiar with that one.
It stands for Universal Commercial Code, I think that's what it stands for.
Yeah, I know what UCC is.
Yeah.
1-308. Let's see what it says.
Yeah, 308 filing says to do this when you go to court. What it's doing is trying to contest
legal protection.
The jurisdiction of the courts.
UCC 1-308, performance or acceptance under reservation of rights. Oh, okay. That was, I think, 203 and 308. A party who, with explicit reservation of rights, performs or promises performance or asserts to performance in a manner demanded or offered by the other party does not thereby prejudice the rights reserved. Such words as without prejudice, under protest, or the like are sufficient.
Mm-hmm.
I have, depends on where you use that.
Well, what it's supposed to pertain to is challenging the jurisdiction.
No, well,
the court's jurisdiction.
You don't need that to challenge jurisdiction. If somebody don't have jurisdiction, you can challenge that in any way. This won't take away any jurisdiction.
Okay.
It just it shows that you did not act voluntarily.
No.
And that's all it shows.
There's a video on YouTube about this, Randy, and it says filings for traffic court, no jurisdiction, UCC 1308.
Okay, that's incorrect.
Okay.
Or it appears to be a non sequitur. Is UCC 1-308, from what I'm reading, has nothing to do with jurisdiction.
Okay. Yeah, it doesn't have any spaces, doesn't have any hyphens, dashes or anything like that. It just says UCC in capitals, 1, and then there's just open space between that, and then it says 308.
Well, there's only one UCC 1, and there's only one UCC 1 with a 308, whether it's put a dash or a dot. Don't make any difference. There's only going to be one of them. Most every state has adopted the federal UCC with the same numbering conventions as the federal UCC. And this is a federal UCC number. So we're on the right one. And, it has nothing to do with subject matter jurisdiction. And I get this a lot of this in the Patriot community, where they may say that the traffic cop had no jurisdiction to start with. And I reserve my rights, so I reserve my right to challenge subject matter jurisdiction. Well, that's not helpful. Now, what it may go to is venue. But even then, it only goes to venue. You can waive a challenge to venue. But I could imagine a peculiar set of circumstances where the court came to you or a court tried to prosecute you in an improper jurisdiction, and you could file a claim, and they require you to file a waiver of venue. Then if they require you to keep them, maybe to get bail, or to keep them from doing some other awful nasty thing to you, then you sign without, what's the exact term, under protest. Then you haven't waived your right to challenge venue, even though you've signed a document accepting waiving venue. That's one. I can't think of hardly any other place where that would be of any value. Certainly not signing the ticket, because you're under contract to sign the ticket. And even if you weren't under contract to sign the ticket, you're signing the ticket in order to keep from going to jail. And that's all. So I don't know why they would put it on there. I do have a problem, and this goes to fair warning. Don't give them fair warning. Don't let them know that you're fixing to come after them by doing things like this, or putting on a pleading sovereign man on the land, free person, blah, blah, blah. That's waving a red flag under the judge's nose. And that's telling him you're going to bring a lot of these patriot issues before his court. Don't give him fair warning. I go in and ask public officials to do things, and the law specifically commands them to, and I don't say, oh, well, the law says you got to do this and you got to do that. I say, well, thank you very much. Where's the local police department? And I go to the police department and says, I tell them, the law says they got to do this and they got to do that, and they didn't do this and they didn't do that. Therefore, they violated this statute. Go down there and arrest them. The first way they find out that I think they did something wrong is when they get a call from the police department, because I'm down there trying to get them arrested. That is so much more fun. You get to see this little chicken dance. When you're asking the cop to go down there and arrest the JP, you get to see the chicken dance. That's where they start shifting from one place foot to the other. Oh, Mr. Kelton, I can't do this. You can't ask me to do that. Yeah, I can. Take your chicken suit off. Oh, Mr. Kelton. Oh, it is great. You know you got them when they start shifting back and forth from one foot to the other.
Yeah.
So, yeah, I wouldn't. Okay, as to UCC 1-308, very few places I could imagine using it. And I would never put UCC 1-308. I would put it under protest.
Okay, under protest. Okay, I'll change to that. So abandon this idea then. Okay.
Next question.
Forma pauperis. Yeah, forma pauperis. Where should I go to be able to make an application for forma pauperis? Because for me to appeal this, I have within 30 days to do so.
Yeah, you can do that. You file that with the clerk. And understand, and forma pauperis doesn't mean that you're indigent. It only means that to have to pay these fees would be unduly burdensome. Hang on, Randy Kelton, Blue Law Radio. Well, it's the last segment, so I won't give out the call-in number, but we'll be right back. Okay, we are back at Randy Kelton, Rule of Law Radio. I think we have disposed of the 308 Patriot Mythology issue. Okay, Truth, next.
Yeah, it seems to be. Okay, all right, that's been clarified. About foreign policy.
Oh, okay, I'm sorry. I forgot where we were at. We were on
the question was
former pauperous. The clerk should have a form for you.
Okay, and that will be at the court where...
Yeah, but in tickets, it doesn't cost you anything. You don't have to take money out of pocket to fight the ticket. So generally, you'll have a notice of appeal and a petition in form of pauperous together in one document. That's what to do here.
Okay. So what's going on there is that she said the judge said it would cost $252 for the filing fee, and you'd also have to post the whole fine up front. Which I think is like $808, $805. So it comes out to like $1,100 or something like that.
Okay, this is for an appeal?
Yeah, this is to make
okay, yeah. Okay, that's standard. You go to the clerk, she should have a form for notice of appeal and a petition in form of pauperous.
Okay, we'll do that. Very good. Thank you. Now, the other question was, what do you think about this? This might be also Patriot Mythology as well. Accepted for value.
Okay, we're going to UCC, and let me do a search on it. I have never found anything that gave that credence.
Yeah.
Okay, UCC 3-303, value and consideration.
Yeah.
An instrument is issued or transferred for value if the instrument is issued or transferred for a promise of performance to extend the promise to the extent the promise has been performed. The transferee acquires a security interest or other lien in the instrument other than a lien obtained by judicial proceeding. The instrument is issued or transferred as payment. That's not it. Okay. Value and consideration. What does acceptance for value mean? There we go.
Yeah, it's something to do with a birth certificate or something like that. It's worth millions of dollars on the stock market, and you're cashing in against the value of your birth certificate and in conjunction using your Social Security number.
Yeah, I've heard all this stuff for years.
Okay.
And I'll keep asking people, show me some statute, case law, documentation. Show me something other than blah, blah, blah. And all I have ever got was blah, blah, blah. Now, I was on Winston Shrout's show, and Winston Shrout is the first one that came up with this bankruptcy issue.
Yes, yes.
And he kind of went through that, and Pastor Massett actually set me up for this. I didn't realize it at the time, because Pastor Massett hosts his show. He set me up to hammer Winston. So Winston goes through all this stuff about the bankruptcy, and I told him, Winston, you're telling me all of this stuff, but you're making all of these statements out of your own mouth. Where is the statute, case law, rules, regulations to support what you're stating? He said, well, I don't know if there is any. Well, Winston, where did you come up with this? He said, I figured it out. You figured it out. Well, Winston, does that mean you made it up?
He figured what out?
And there's this long pause, and he said, well, yeah, I made it up. I said, Winston, I'm a creature of statute. I can't go into court with, I made it up. No. I need something hard. I never have gotten it.
Okay. Okay.
And the pastor hosts. He gave Sam Kennedy his start, and he's hosted a number of people promoting the commercial process. And this is what he said to me. I like these people. I think they're right-minded and good-hearted people. He thinks Winston Trout hung the moon. But he says, I have never seen anyone achieve remedy using the commercial process.
All righty.
So,
well,
and I've been doing the show all this time, and people keep coming to me with it, and I keep asking for, where is it? Where is foundation for it? Never got it. Common law. Where's the common law? I can't find it. Where do I look for it? Nothing.
Yeah. Well,
so it's frustrating to me.
Patriot mythology, I guess. Well, I was going to do this for what it's worth, Randy. I have these two bills, $2,000 for one and the other $2,000 for the other, totaling $4,000. I was going to go ahead and use their method. There's an instructional video on YouTube using this, accepted for value. What you do is you write it on the form that you send back to them, to the collection agency. Money order at the top. You write in your name, your Social Security number. Beneath that, exemption from levy, deposit to the U.S. Treasury, and you sign off on it and send it back to them.
Okay, good luck on that. I was called to New York City to get a guy out of a federal lockup who bought a Mercedes with a bill of exchange. They didn't prosecute him. Apparently, there is some substance to all of this because they didn't prosecute him. But they held him in jail for a month. And I got there, and his wife was saying that they had backdated some documents. So I go in there in a suit, and I'm carrying the documents that were backdated. And I looked at the date stamp on it, and I looked at that and said, man, that looks like a rubber stamp. It looks like one of those little stamps where you can roll the months and days around. So I went in there and asked them what they used to, I showed them this document. I said, it's got this date stamp on it, but it doesn't appear to be one of those electronic stamps like that thing up on the wall there. She said, oh, no, that one's broke. Now, this is the federal court in Brooklyn, New York. It's broken. We use this one. She takes it out and shows it to me. And I said, can I see that? She said, sure. And I take it and I look at it. I said, now, when you change the date on this, you just kind of roll this thing around? She said, well, yeah. I said, will it roll backwards? And I rolled it backwards. She said, can I see that? She takes it and zip, she's gone in the back. 30 minutes later, they were processing him out of jail. So they were backdating documents. However, and that's the thing about this. When you do this, Tim Turner was pushing this kind of trash. Tim Turner's in jail now. Sam Kennedy was pushing it. He's in jail now. People do this and they get in trouble and they go to these guys and they say, well, you see this I here? You didn't dot that I exactly right, and you forgot to cross this T. This is dangerous stuff. And this UCC, one of these UCC forms that they were using, it's an OID form, they were using it to get money back from the IRS. They brought this thing to me, and I looked at it and I said, you just file this form and they'll give you back all your tax money. That just doesn't seem right. And it's my rule, if something doesn't seem right, it's probably not, so I'm going to avoid it.
All right.
And everybody who got into that, most of them got a bunch of money back, and then the IRS landed on them like a ton of brick. 1099 OID, that's what the garbage was about. All this patriot mythology junk out there.
All right.
So I haven't been able to find anything of substance to back the commercial process.
Okay.
At all. And all this birth certificate stuff, I found nothing to indicate that the birth certificate is anything other than a document certifying that you were born on this day at this time. I just can't find it.
All right.
And I can't get anybody to give it to me.
There's a lot of claims that on the back of that is a number that is invested in the stock market and is registered under that number. So
okay. I had a guy that worked in the Securities Exchange, and what he's saying, these numbers that they run this number and they find a security under that number. He said there are so many securities out there. You give me any 10-digit number, and I'll get a hit on it.
Mm-hmm.
They're running their Social Security number and claiming that. I'm sorry, not 9-digit. They're claiming that they're finding the security. He said, no, they're just finding a security that happens to have that number. Then everything to do with birth certificate. So I have found nothing to back that up.
All righty. Well, Randy, thank you. At least I have the form of papyrus and I know what to do with concerning that. The other question will have to wait till another time.
Okay. Thank you very much. This is Randy Kelton, Blue Law Radio. We'll be back next Thursday, 8 p.m. Central. Thank you all for listening, and good night.
All right. All right, Randy.